Welcome to our October 2023 edition of This Month in Payroll. I'm Claire Soccio, a partner in PwC's payroll advisory practice. In this edition, we will explore the Office of the Fair Work Ombudsman's 2023 annual report, an update about Payday Super, and another High Court decision reinforcing the distinction between an employee and contractor. On the 23rd of October, Ms Anna Booth released the Office of the Fair Work Ombudsman's 2022-23 annual report. For the second year in a row, it announced a recovery of more than $500 million in underpayments, with this year's wage remediation recoveries totalling $509 million for some 250,000 workers, just shy of last year's total recovery of $532 million. This year, 43% of amounts recovered relate to large corporates and 19% to universities. The FWO entered 15 enforceable undertakings and filed 81 litigations. Notably, the litigations included allegations of accessorial liability levelled at master franchisors and a holding company. The report reflects on the success of the FWO's targeted compliance activities, which were guided by the compliance and enforcement priorities established last year and used intelligence to deliberately target businesses that were likely to be non-compliant. Of 977 targeted compliance activities, the Office recovered some $77 million in unpaid wages. Most contraventions resulted from the underpayment of hourly rates, failure to pay correct weekend penalty rates, and advertising pay rates in contravention of the Fair Work Act. One key priority was large corporates, which are defined by the FWO as having more than $250 million gross income in a financial year. The Office's observations about non-compliance by large corporates were consistent with the prior year. The key drivers including annualised salary arrangements that don't adequately compensate for minimum entitlements, failure to implement enterprise agreement obligations or undertakings, ineffective governance, a lack of investment in payroll systems and staff, record-keeping systems, expertise and auditing, and failure to address known issues before comprehensive organisational reviews are completed. This last one's an interesting one, perhaps reinforcing an expectation that known issues need to be remediated promptly and shouldn't necessarily be held back until all issues are identified and able to be addressed together. Another priority was universities. After writing to the university sector in late 2020, outlining its concerns about potential underpayments and identifying the sector as a priority for the past year, the Office is now engaging with more than half of the university sector in some capacity. During FY23, the Office commenced enforcement action against 4 universities, including federal court proceedings with 1, and entering enforceable undertakings with 3 others. The common themes identified by the FWO for this sector include the high volume of casual workers, poor governance and management oversight practices, lack of central human resources functions, lack of investment in payroll and time recording systems, and control over human resources and pay-related issues being devolved to individual faculties and dealt with by academic managers rather than HR and payroll subject matter experts. Recognising the significant complexities faced by the university sector at large, the Ombudsman has focused its investment on proactive education to encourage workplace compliance. This has included engaging with individual universities, peak uni bodies and government agencies, and the Australian Universities Accord Panel. As we look to FY24, the FWO will continue to navigate significant changes in the regulatory landscape, including workplace reforms expected to flow from the Secure Jobs Better Pay, Protecting Worker Entitlements, and Closing Loopholes amendments. Amongst all these ongoing changes, the Office will continue to target priority sectors in FY24. Consistent with last year, this will include agriculture, fast food restaurants and cafes, large corporates and universities. And new to the list of priority sectors for the year ahead are building and construction and care. The Ombudsman notes that all employers, including and especially large corporates, must place a higher priority on addressing payroll issues, enhancing workplace relations systems and governance, and engaging expertise to ensure they are paying employees their lawful entitlements. It's evident that the focus on employers' wage and entitlements compliance remains strong and this topic rightly remains a priority concern for boards and executive management. Payroll leaders need to ensure that their governance structure supports this environment of significant scrutiny and change, and that appropriate investment continues to be made in education, resourcing, and technology. And on the topic of change, this month, Treasury released its consultation paper detailing its proposed introduction of Payday superannuation from July 2026, and seeking input from interested stakeholders about the policy and legislative design. Payroll is obviously one of the most interested stakeholders. As we know, Payday Super is being designed to benefit individuals by enabling earlier receipt of super contributions, thereby maximising potential investment returns, and allowing easier reconciliation of super contributions disclosed on payslips against those received by the super fund. Equally, this change will also benefit employers by simplifying and streamlining the payroll process, and benefit the ATO by enabling more timely and accurate matching of employer wage and super data, and thereby allowing it to target its investigative activities to those employers most at risk of non-compliance. As this initiative moves from concept to design, the consultation paper explores a range of specific details that need to be considered and addressed in the new rules. Examples include whether payday should be defined as the date on which a super contribution must be paid by the employer or received by the fund, whether the due date should be the payday itself or another date within a threshold number of days after payday, whether there should be a grace period during which employers can self-correct their errors, for example by making catch-up payments, how Payday Super should work for out-of-cycle payments, over what frequency the ATO's data matching and reconciliation processes should sensibly be performed, and whether the current compliance regime, including SG charge assessments and calculations, is suitable in a world of Payday Super. The paper also considers the interplay between onboarding, choice of fund, super stapling, and Payday Super. In good news for employers, it contemplates a new digital tool that would integrate ATO records with employer software to streamline the confirmation of stapled super fund details. This could significantly reduce the administrative burden and system shortcomings currently faced by some employers managing the stapled super process. The release of this discussion paper allows payroll professionals a rare opportunity to have meaningful input into the design of this process. We strongly encourage you to review the paper and to consider the operational implications. The document is available from the link on your screen, and submissions are due by the 3rd of November 2023. In the meantime, while we await these Payday Super changes, the ATO is moving forward with its commitments to use single-touch payroll data to review employers' super guarantee compliance. Emma Rosenzweig, the ATO's Deputy Commissioner Superannuation and Employer Obligations, announced this month that from early 2024, the ATO will employ even more powerful analytics to detect employers that may not be compliant with their obligations. And still with superannuation, the High Court this month rejected an application by the Commissioner of Taxation for special leave to appeal the full Federal Court's decision in JMC Proprietary Limited against Commissioner of Taxation. This denial further reinforces the basis for the distinction between employee and independent contractor in the context of super guarantee contributions. In this case, an education provider, JMC, engaged a lecturer, Mr. Harrison, as an independent contractor to provide teaching services. The Commissioner of Taxation argued that Mr. Harrison was an employee of JMC, and therefore that JMC was liable to pay super contributions for him. In reaching its decision that Mr. Harrison was in fact a contractor, the full court upheld the principles already established in JAMSEC and personnel contracting, both cases that we've previously explored in detail, and concluded that the common law employee or contractor determination relies on an assessment of the terms of the written contract. The court focused primarily on Mr. Harrison's contractual right to subcontract or delegate his responsibilities, concluding that his agreement with JMC did not require that he personally deliver the teaching services, and Mr. Harrison's control in relation to how the teaching services would be performed, deciding that his lesson plans were not prescriptive or mandated, and as such, he had a high degree of contractual autonomy as to how he would teach the agreed content. The Commissioner of Taxation requested special leave to appeal this decision, arguing Mr. Harrison should have been considered an employee as the contract was for the principal purpose of his labour and not for the labour of any subcontractor. The High Court's rejection of the leave application again reinforced that the executed contract between the parties is key to the analysis of whether a common law employment relationship exists. While not the sole determining factor, a right to subcontract or delegate, even where not exercised, may be incompatible with a common law employment relationship. As Rowan discussed last month, the government's Closing Loopholes Bill, which is currently before the House of Representatives, proposes to introduce into the Fair Work Act, but not tax legislation, an interpretative principle for the definition of employee. If it progresses in its current proposed form, the definition would somewhat reverse these recent High Court decisions and instead require consideration of the substance and practical reality of the relationship. Until any such changes are legislated, employers engaging workers as independent contractors should ensure that contracts are drafted in a way that accurately reflects the parties' respective rights and obligations. And lastly, a quick acknowledgement of a decision that touches on the topic of pay secrecy. The Fair Work Commission this month ordered a Gold Coast employer to compensate 2 employees that it had terminated unfairly for discussing a third colleague's pay over a social media messaging platform. There was a complex web of mistruths involved in this matter, which we don't need to go into. But what was of interest was the Commissioner's observations that the terminated employees were unaware they were not authorised to share the third colleague's pay details, and that neither understood that the details may be confidential. The new provisions of the Fair Work Act that prohibit pay secrecy did not apply in this scenario because the terminated employees were discussing a third person's pay and not their own or each other's pay. Notwithstanding, the Commissioner considered these laws as relevant background matter, and when considered together with other factors, concluded that the employee's conduct in sharing the pay details was not a valid reason for dismissal. While the facts of this case are rather extreme, it does serve as a reminder for employers to make sure they are familiar and compliant with the new laws prohibiting pay secrecy. And that's it for this month in Payroll. If you would like to revisit any of our prior updates, they're available on our website at pwc.com.au/payroll. And if you have any questions or need for support, please reach out to myself or your usual PwC contact. Until next time, have a great month in Payroll.